2. So you know what? 2 minutes passed. Good morning, everyone. I'm Giovanni Cautillo. I am the president of the OGCA, and we have for you yet another installment in the OGCA webinar series. Today is a different webinar. It's about adjudication, entitled A Practical Tool in Construction Dispute Resolution. Now, I'm joined by two amazing panelists. I'll introduce them to you shortly, but I do want to give you a rationale for this webinar. The impetus for this webinar was basically, we haven't heard a lot about adjudication, and predominantly due to COVID and it's the slowdown in construction in regards to the Construction Act, that is. And because of that, I've been inundated with a number of questions from our members about adjudication. So I thought, what best to do than go to the source and discuss it with ODAC. And bring in someone that can actually provide you with a liaison between the contractor's perspective and the adjudicator's perspective. So I would like to introduce you to our esteemed panelists today. So we have Elise Teitler. So Elise is known as the project manager for ODAC, and ODAC, by the way, is Ontario Dispute Adjudication for Construction Contracts. They have a contract to do all the adjudications for the Construction Act for a term of about 5 years or so, but I'll let Elise discuss that with the audience. So, so she is a practicing lawyer, just so everyone knows, but in her capacity as the project manager, she is the liaison or the go-to when it comes down to all things adjudication related. She has both been a commercial litigator in a downtown Toronto law firm and served as in-house legal counsel for a large television broadcaster and a software company. And clearly she is motivated at being a litigator and whatnot in order to ensure that, you know, there are disputes and there's settlements and they're negotiated so that the resolution comes and it's amicable and best for both. And she also is quick to issue a push-up challenge to anyone that wants to take her on. She will blow you out of the water. Anyway, with that being said, we also have Matt Ainley. Now, Matt, again, for most in the audience, they'll recognize Matt since he's been in the construction sphere for, I think, about 4 decades or so. I don't want to overstate, but sadly, about 4 decades or so, sadly. So Matt is currently a construction consultant and an ODAC adjudicator. And so he has become a construction consultant since his retirement from Bird Construction. But Matt kind of basically cemented himself in the industry as a fixture in his role as the president and chief operating officer for Van Bots Construction. So this is a company he served with for over 25 years. This is something that you don't hear about, you know, in today's day and age where people spend over 2 decades in one company. So, so through all of this experience and whatnot, Matt will be in kind of a keen contractor's perspective on the entire adjudication process, and is kind of here to clarify how the process is beneficial for our industry. So let's just go on to the agenda for a second. So I don't have control of the slides, Elise does. So as you see in the agenda, what we're going to do is these are basically the questions that I tabled to Matt and Elise when we first had this initial conversation, and I bombarded them with all these questions. So instead of, you know, them sitting here and answering me, they thought it beneficial to instill for everyone an agenda. So these will be the points that we're covering. So just as a point of order, if anybody has any questions, I would very much like for them to be put into either the question answer section or in the chat section. We'll be reviewing them on a regular basis. And I just noticed that there's a question here by Andrew Shefton. Thanks, Andrew. Yes, there are still very few adjudications. We're going to hit that in a second and we'll go through it. And so we'll answer this live. Thanks, Andrew. Andrew is busy typing today. Okay, so you'll be sure, as you can see, we haven't even started it. We have a plethora of questions. So you're going to get a lot. But I do want to kind of hand this over just as an initial introduction to Matt. I'd like to know, Matt, let's start off with you, and I would like you to hear from you what you believe our participants will take away from this presentation.
Thanks very much, Giovanni, and good morning, everyone. So the idea today, Elise and I got chatting about how to best get the use of how practical adjudication is and how ODAC actually works and how easy it is to actually use the ODAC system. So a little bit of background that Giovanni actually touched upon, which was when the Construction Act was passed into law, we needed an authorized nominating authority, which is identified under the Act. And the Attorney General's office put out an RFP and received competitive proposals for the authorized nominating authority. And ODAC won and has subsequently set up that authority and started operating in October of 2019. They were obviously working very hard in the summer of that year, but that's how it got started. So Elise leads that for ODAC. And so they administer the process of adjudications, and Elise will get into more detail for that. And I think it's an important distinction. And the other part we really want you to understand is, like, everybody understands in Ontario, right, you have lien rights. And so, you know, that is often the way disputes get managed, because if you're not getting paid, you lien. Well, you now have a new option, and adjudication is that option. And you don't give up your lien rights. In fact, you still have them, but you can actually adjudicate an issue and get it resolved very quickly. And we all know lien resolution is not quick, and it's also very expensive. So relatively speaking, adjudication becomes a new option for the construction industry and everybody in the supply chain, from the owner right down to the lowest supplier subtrade in the supply chain. So that's the important part we want you to fully understand. And we're going to get into some practical things. And I think Giovanni's quite right. Ask your questions. We want this to be quite interactive, and we'll try and we'll get through a bit of a small presentation here, and Elise is going to take the ball here right now. But and then once we're done, we're going to fire away with the most of this presentation. In fact, will be questions, so we can help you people begin to understand how this really works. And it appears complicated. It's not as complicated as you think. Elise.
Well, thank you, gentlemen, and thank you, members of the OGCA. I'm really honored to be here, and I guess my role, as Giovanni mentioned, is I am project manager of ODAC, but more importantly, I feel like my role is also that of an educator. I'm really anxious to educate the public and the rest of Ontario that there are other options out there for construction disputes in terms of going to court and arbitration, and every dispute has its place. And I think this should be welcomed with open arms in terms of having this option open to people in terms of the efficiency, the cost effectiveness, and a whole host of other reasons. But I think as Giovanni rightly points out, most people don't understand what adjudication is. So hopefully today, with Matt's input and Giovanni and your questions today, we can all go away with a little bit more of an understanding and an education about what adjudication is. So let's start off, pardon me, with just a simple definition to put it all in perspective. So under the Construction Act, it really is an alternative dispute resolution process. We all know about courts, arbitration, and the lengthy time that's involved with that. This is an independent process. You've got an independent third-party person who is going to hear submissions from both parties and that's known as the adjudicator, and then make a decision at the end of the day. The party that brings the claim to the table, or the notice of adjudication, is known as the claimant. And the other party is the respondent. It could be a claim for money owing, valuation of services, what have you. Matt's going to get into, what areas you can adjudicate. But that is essentially it. You've got a third neutral independent party known as your adjudicator. And Matt also has some firsthand experience because he is an ODAC adjudicator, and he'll speak to that a little later on. So I'm going to hand it over to Matt, and he's going to actually go through. And these are some of the provisions. We don't want to bombard you with legislation, pardon me, but I think it's important for everyone to know what can and cannot be adjudicated. So Matt, if you want to take it from here.
Thanks, Elise. So prompt payment prompt payment and adjudication go together. They're a yin and a yang, if you like. And adjudication is the enforcement part of prompt payment. So prompt payment, as you now know, under the new act, have 28 days to pay from the owner down to the general contractor or the main prime contractor. And then from there, it's just a cascading 7 days as you go down. So if there's a dispute and you need to get something paid that should be paid, and the party above you in the supply chain is not paying, then you can adjudicate. And so payment for your monthly bill, payment for change orders, and in this particular case, and this is what's really good, because we all know as contractors, whether you're a sub-trade or a general contractor or a prime contractor, you know that changes are often held up for a number of different reasons. They're not being processed by the trades fast enough, the generals fast enough, the architects, engineers, or they're being held on to by the owners. So you can adjudicate change orders or approved or not. They could be a change notice. So you have the ability, if you're disputing over the value, you can dispute it changes. And that probably makes up on certain large commercial projects, maybe as much as 25 to 50% of the slow payment issues. By experience, that has been mine anyway. And so any disputes around non-payment in that way are allowed. You can dispute any set off by a trustee under the Act. Or any lien set-offs. So in other words, if your lien is due and you don't get paid all of it, you can dispute that, and you can dispute any holdback and any amount of that holdback is also disputable. And the last item, number 7 here, is actually really interesting. Any other matters that the parties might agree to. So the Act is wide open. Well, it is, it's law that you can go after, and nobody has a choice. So in other words, if you're the painter on the job and you're not getting paid by the general because maybe the general's not getting paid by the owner, the painter can adjudicate on payment issues. But if there's a dispute between the painter and the general contractor that is not related to payment, if the two parties agree to that, they can adjudicate that dispute as well. So it's a bit of it's pretty wide open, but it's also specific when it comes to payment. Elise?
Yeah. And just to your point too, I mean, 13.5 sub 2 deals with the subcontract issue. That's what what you just hit on as well. I think the other interesting point to note as well is when we look at the other key components in terms of when you can and cannot adjudicate. If the contract or subcontract is already completed, you're out of luck in terms of adjudication. And that deals with that sub 3, multiple matters. And as you see, as we go along this process and you see how quick it is and how efficient, you'll understand the next point, sub 4, where we're only talking about a single matter. So if you've got a construction project and there's multiple issues or multiple disputes on various matters, you're only adjudicating one matter per adjudication. Again, the simplicity and the one matter will make a lot of sense when Matt goes through the timelines and you see how these things roll to the finish.
So,
and then, sorry,
so just to add to that, I mean, that's an important point. So, I mean, I've done a couple of adjudications to date. So one of the things that, when a single matter can be as simple as, hey, we're fighting over whether this particular item is in or out of the contract. That's a single matter. But the second matter would be, we're also fighting over what it's worth.
Right.
So the parties are allowed to adjudicate more than a single matter, but they have to mutually agree that with the adjudicator. So again, the Act is flexible.
So do the parties, do the two issues have to be tied together like you just named, Matt? Okay, it's a timing issue. Does it belong in the contract or not? And what is the cost of it? Do they have to be related?
They generally have to be related, or they are the two matters. If they're separate, completely separate matters and not related, Giovanni, the parties can agree to have an adjudicator do those as well. Okay.
Isn't that a bit of a landmine? Like that's a minefield, isn't it? Because
it could be, but it depends on the issue, right? But I mean, if they're separate matters unrelated, you generally would want to have another adjudication, because if one matter happened to be complicated, you might need the full 30 days in the time frame we're going to get into to actually deal with it appropriately. So it just depends on how big and complicated they are. So anyways, I think the point to the audience is the act is flexible, but the parties have to mutually agree on what matter or multiple matters are actually being adjudicated at the onset of the adjudication. And we'll come to that in a minute.
Excellent. Keep going.
Right. And I think another important point, and this actually, I get a fair number of questions from people on the outside asking me this as well, that you still can refer a matter to adjudication, even though that matter is subject to a court action or arbitration. So this also, adjudication can go on over here while the court action is still going on over there. And I think, as you will find out and see as we go through, with the court system, we were already backlogged before COVID. So you can only imagine where we are at now. So people may, with their court actions over here that are sitting, and I do mean sitting, may decide, hey, why don't we go and adjudicate the matter and see if we can get a quick and easy resolution. Matt?
Okay, so this is a boil down of all the fancy words inside the act and to something that's somewhat understandable. And one back.
That's me. I'm sorry. I don't know what happened.
Okay.
Yeah.
We're experiencing technical difficulties already.
There we go.
There we
There we are. I'm gonna put my glasses on for this one. Okay. So for the audience, and these slides will be available so you can have it. I've tried. We've put together something here as a bit of a timeline, and that it comes right out of the act and refers to some of the clauses in the act to sort of speed up your sort of peeling back the onion as you get into this if you're in an adjudication. So a notice of adjudication has to be filed by the claimant. That's the person submitting the adjudication, as Elise said just a few minutes ago. And the person receiving it is the respondent. So claimant and respondent, sort of basic terms that are in the act. So it's submitted, and when the claimant submits an adjudication, then they have to put forward 1, 2, or 3, or 4, whatever number you want, a number of adjudicators off ODAC's certified roster of adjudicators that you would be comfortable using. And you want to think about it in terms of the ones that they would be comfortable using too. And I'll tell you why that is in a second. So there's 4 days for the claimant and the respondent to agree to the adjudicator. And if you can't agree to the adjudicator, then it goes to ODAC to actually put forward the next person up on the roster to adjudicate. And ODAC has 7 calendar days. So all the days you see here, by the way, are calendar days. That's how an act works. They're only in calendar days. So ODAC will take 7 days to find the appropriate adjudicator, put it forward, and then once that adjudicator accepts the assignment, then the claimant has 5 days to submit all the documents that it intends to rely on for that adjudication. And then the adjudicator, according to regulation 17.3, in fact, the adjudicator will set the time frame for the respondent's submission of documents. They'll often give the respondent a few more days, and that can vary depending on the complexity of the adjudication. And once the claimant's documents are submitted, you can see there that there's a 30-day timeline for the adjudicator to render their decision. Now, the adjudicator and or the claimant and the respondent can ask for an extension up to 14 days. And it has to be mutual between all 3 parties. So there is also a further clause that basically says that the parties can agree to any time frame they want. And there's a reason for that, and we'll talk about that in a few minutes. It's a part of a cultural thing that will.
Oh, is Matt frozen?
Matt's frozen for a minute. Yeah.
Oh, that's great. Welcome to technology. It's wonderful until it doesn't work. And so, all right. So I'm going to ask a question of Elise right now, seeing as how Matt is stuck in limbo over here. We've got a question that came in regards to, can you adjudicate project delays and delay claims? So those are 2 separate and distinct, clearly. So I guess the claims part of it, they're monetized, so you can, I'm assuming you can, but what about project delays when it comes down to timing?
Well, yeah, that would be a matter that you know, I'm a little adverse to sort of give legal advice in terms of what you can and cannot adjudicate in terms of my role as the project manager for ODAC. But what I would say to people is, and I get these questions all the time, they'll give me different scenarios and say to me, well, can I adjudicate this or can I adjudicate that? In my role as project manager, I'm not really going to give legal advice in terms of what can and cannot be adjudicated, unfortunately. So what I would say is refer to your act and speak to counsel in terms of what you can and cannot adjudicate. And again, to Matt's point too, you've also got that basket clause there in terms of what the parties will mutually agree to adjudicate as well, which will help you out.
Clearly. All right, so let's advance the slide, and then when Matt comes in, if we have to, we can jump back and forth. It's unfortunate that his internet. Where is he again? Like he's in the boondocks or something. Well, he'll be back eventually. So
he'll be back. So you know, the main theme, at least from my end and with my ODAC hat on, in terms of educating Ontarians out there, is adjudication has a lot of benefits. You know, Matt touched on this quickly. It's available as of right. So you don't need to get the other party's permission to say whether you adjudicate or don't adjudicate. It's available as of right to all the parties in the supply chain. It's an interim process. What exactly does that mean? It means that you are going to get a decision, and that decision is going to be binding unless and until you have another court decision or an arbitrator's award that says otherwise. So that's going to be your binding decision. It is quick. Matt touched on that. I'm going to let him finish up. I'll just in a second. It is a quick process. It's very cost effective and relatively inexpensive. And when I get into the ODAC system and talk about fees, you'll see what I mean about that. And the payments, and Matt, when we go back to the timeline, we're going to go back right now because we have them back, but you'll see the payments that are ordered pursuant to a determination have to be made within 10 days, and it's enforceable just as a court order would be.
Great. So, sorry, folks. I don't know what happened there.
Well, clearly. So I should tell you that Matt is probably broadcasting from, was it the south of France right now? Because, you know, he globetrots on a regular basis, and the internet there is not as good as it is here in Canada. So Matt, where were we? We lost you in mid-sentence.
Okay. So the 10 days to pay, as I think Elise was just talking about. So so the winning party doesn't get paid in 10 calendar days, then they take the notice of determination by the adjudicator, file it with the court, it becomes a court order. Then they have the right to walk off the job without breaching their contract, get demobilization costs, get interest costs, and when they finally do get paid, they get mobilization costs to go back onto the job. So there's great power in the adjudicator's determination because it's backed up by a court order. And all the lawyers, as Elise will attest to, love a court order. That's just the thing that is just, it's the bee's knees in our judicial system. So it does have real teeth, adjudication. If you have a real dispute and you want something done quickly, this will work. So that's the basics of adjudication in a nutshell. I don't know, Giovanni, if you've got any questions at this point.
I do, and I've got some really juicy ones actually.
Okay, great.
these are good, and that might be controversial, but you know. So I tried to ask Elise, but she stick handled around it. So I'm going to ask you instead.
Thanks a lot.
Not a problem. I said, you know what, you got to keep you on the hot seat, right? So, can you adjudicate project delays and delay claims? So I can understand, you know, the delay claim side of things because it's monetized. There's a claim aspect of it, but what about the project delay, the timing of it?
So if it is a cost issue for the service, you can bill delays. You can adjudicate delays, I'm sorry, because there's a cost issue, right? You're fighting over the cost and value of the services. Okay, it's a dispute. There's many ways to put that in. I mean, if you look at it, you know, if you think about it in terms of a commercial contract and a CCDC2, you know, you're supposed to give notice under your contract. And if you're giving proper notices of delays under the contract, those delays will have costs, and you can submit those costs. You can submit a change request, and changes are allowed to be adjudicated. So there's ways to legitimize it, and I think you'll find that it's going to be well within the scope of the definition that we were talking about, that Elise showed us just a few minutes ago.
Excellent. So I'm going to go back and now harp on Elise and put her on the hot seat just because I feel like it. So Elise, does ODAC have the ability to deny an application for adjudication?
No, ODAC itself does not have the ability. We administer the adjudications. And so if that would go to an adjudicator, it would be the adjudicator's decision once the claim and the response, if a response is in fact filed. It wouldn't be a rejection, but it would be, they would come to determination in terms of how they're going to respond to the adjudication. We cannot deny one.
Right. So I think to sort of add on to that, one of the adjudicator's first rules is to determine whether the adjudicator has jurisdiction to rule on the adjudication that's been filed by the claimant. And so there's a couple things one looks at. Number one, does it fall within the definition of 13.5? And also, does it fall within the Act? You know, we're in transition right now, so there are 3 versions of the Act that are out there. The old Act, the Act that has the modernization piece of the new Construction Act, then the Act that actually has prompt payment adjudication in it, which started in October 2019. And the definition of where your project is does it fall within which one of those 3 acts? And so that's one of the first things that all the adjudicators are doing. They're looking to see if they have jurisdiction. And so it's a very important part of the adjudicator's role is to determine whether the adjudication is in fact falls within the definition of the Act and in the new Act by time.
Okay, so I've got a blatant question that I know everyone is dying to answer. Can you contract out of adjudication?
Nope, there is no way.
Fantastic.
So all parties, all construction companies, not individuals, but construction companies, or any party providing a service that has provided a service by the definition of the Act, all the supply chain has the unfettered right to adjudicate.
Okay, fantastic.
Within the definition of 13.5 in the Act.
Understandably, they're not going to adjudicate, what paint color belongs on the wall. But let's move along here, because I have a lot of the questions that I'm getting in are about costing. I know we're going to touch upon cost in a moment, so let me hand it back to our panelists so they can resume their presentation.
Okay, and I guess that actually ties in nicely in terms of you're asking me, can I reject an adjudication? So I'm going to tell you what I can do as the authority. And I will tell you at the end that if you do need to reach ODAC and you need to reach me, my email is authority@odac.ca. So there you go. So,
why was enforcer at ODAC taken? Is that why? Okay, got it.
I asked for it, but they didn't give it to me. What can I say? I tried. So what is it that we do at ODAC? So again, Matt gave a great overview in terms of how we came to be, and we are the Authorized Nominating Authority appointed by the Ministry of the Attorney General. And we admit for all of Ontario, we are the provider of adjudication in terms of overseeing and administering and giving support to adjudications, both in terms of support to the parties to the adjudications and also support to our certified adjudicators. We have 66 on our registry, and we'll get into that. We also train our adjudicators. So we have training courses that happen throughout the year, and our adjudicators, people take those courses not just for people that want to become adjudicators, but people want to learn more about adjudication and the ODAC system. So we have training for that, and then we have refresher courses. So we train them. After that, people apply, and certain individuals are chosen and certified as ODAC adjudicators, and then we come to our Adjudicator Registry, where you can find a really proud to say diverse group of individuals. We have project managers, engineers, consultants, lawyers, various backgrounds, at least 10 years in the construction industry, on our Adjudicator Registry. So proud of the group that we've put forward. As Matt also pointed out earlier, and we'll go through sort of the start and finish of an adjudication, but when the parties cannot agree on their adjudicator, they come to us and we will appoint an adjudicator. Similarly, the parties will also meet about their fee for their adjudication. We'll talk about how we get to that. If the parties and the adjudicator cannot, for whatever reason, agree on their fee, we are going to set the fee, and I'll tell you how we do that as well.
So Elise, before you go, just to add on to what you say, which is right on the spot. So from the adjudicator's perspective, there's a couple things you really want to think about. Providing a fairly decent amount of information about what your claim is about is pretty key at the onset of this. The adjudicators are grumbling because you don't really get enough information in 2 sentences, and you're trying to determine, if you're being asked, are you qualified as an adjudicator to deal with that type of situation between the 2 parties? So you want to put enough information so the adjudicator can look at it and say, yeah, I can or can't do that, and because that's important to a good decision. The second thing is, you do really want to work hard at agreeing who the adjudicator is, because the way that the rules are working, that ODAC will assign to you the next adjudicator up. So you got to think about it. You might be getting a lawyer or an architect on something that's maybe a very complicated soils issue, where you might actually want a civil engineer or somebody that's been in the construction business for a long time and understands the technical nature of a soils report. And that is sort of the why you want to agree, because and obviously the adjudicator may look at it and say, hey, listen, I'm a lawyer, I can't understand this, I'll decline you, Elise, right? And but it's important to get the right adjudicator, because if the adjudicator does their job correctly, the decision is going to stand. And you're going to be maybe not happy with the result if you're the losing party, but you're going to know that it was maybe the right decision. So that's a fairly important distinction in this type of dispute resolution.
Yeah, and Matt, just on that point, when I go through and I look at the adjudications, and we'll get into some stats because I know everybody's anxious to hear the real numbers out there. When I went through and looked at, an overview of the adjudications and said to myself, well, how many people are actually mutually agreeing? And, what's the stats on that? How many people are actually mutually agreeing and selecting their adjudicator together? And how many are asking ODAC to appoint? We're at 43% where the parties mutually agree to an adjudicator, and 57% asked ODAC to appoint. So pretty close, interesting. And when we go through the system, you'll see this whole back and forth. One suggests and then the other, and back and forth. And sometimes it's sort of like a tennis match and there ends up being agreement. And sometimes the parties just say, ODAC appoint. So it's an interesting process. I will say that in terms of even learning more and educating yourself, I really encourage everyone out there to visit the ODAC website. It's odacc.ca. It's a very informative website, and I say that having no hand in the pot in creating it. I think it's a great resource. It really helps you walk through the adjudication. Even I'm going to do it today, so don't feel that it's too much or if you missed something, because if you did, it's really all on the website. The starting point and we'll get through walking through an adjudication. The starting point also, if you want to commence an adjudication or you want to create an account, is also starts by visiting the website, top right corner, log in, create your account, and that's how you're going to start your adjudication. You can also just create an account if you're not ready yet to start an adjudication. So please use the website. It's helpful in many ways. And let's talk about a little bit the adjudication fee, just generally speaking. That's a fee that's going to be paid by both parties to the adjudication. And as I mentioned before, same as Matt pointed out, either parties are mutually agreeing on the adjudicator or they're not. Similarly with the fee, when you have an adjudicator on your case, the adjudicator with the party is going to sit down, they're going to discuss the fee. So either there's going to be resolution and the parties are all on board in terms of the fee proposed, or there will not be resolution. Similarly, if there's no resolution, then the adjudicator will ask ODAC to set the fee, and I'll go through and tell you how we do that and the fees involved. The other thing you should know with whatever fee is set, the claimant will pay an additional $500 for claims over $50,000. It's known as a referral fee. That's just what the claimant's responsible for. Otherwise, there's no additional fee for disputes below the $50,000 mark. And similarly, there's a $100 fee that's split between the two parties, $50 each, for claims that are over $50,000 as well.
So question, if I'm
Sure.
a claimant and I have to initiate an adjudication because, you know, I'm not being paid or something, is that $500 recoupable? Can I put it in as part of my claim so that I can get the money back? Because, you know what, I need to claim in order to get the 50,000. Can I put the extra 500 in there? Just curious.
Well, that's a good question. So, you know, that fee is just a fee that's paid to ODAC. It's a matter of whether the adjudicator at the end of their decision is going to make a cost award against the, I won't say the losing party, but the party that has to pay. You know, for the most part, in terms of what I've seen, and the Act provides for this, that the adjudication fees are going to be, you know, mutually shared 50-50.
Exactly.
They're
right.
split equally. It is there is provision in the Construction Act in terms of the adjudicator being giving the authority that if they want, they can order costs, assign costs differently at the end of the adjudication in frivolous and vexatious sort of cases, sort of bad faith cases. In terms of what I've seen at ODAC of all the adjudications, just another fun stat. I've had one case where the adjudicator asked that one party pay the full fee and not split it 50-50.
So the Act's designed to give the adjudicator. The adjudicator is not a judge. They're more of an inquisitor and can conduct the adjudication. They have pretty broad scope of to be able to go through the information and request information to get to the determination. But one of the things that the Act provides, it as Elise just said, is if one party is, you know, behaving badly and, you know, not acting in a fair manner, then the adjudicator has the right to assign costs. So that's probably the only time you're getting your $500 back. Otherwise, that's, you know, they are the costs, and the Act's pretty clear that all the costs are to be split equally, as Elise said, unless there's you know, a bad behaving party.
Right, but it's, as Matt said, it's within the adjudicator's discretion.
Correct.
So here's my chart dealing with the adjudication fees, and this is with the schedule of fees. This has been set by the Ministry of the Attorney General. This is not an ODAC made up fee. This comes into play when ODAC is asked to set the fees, and it's all tied to the amount in dispute. So you can see for claims that are under the $10,000 mark, you're at a flat adjudication fee of $800. 10,000 to 24,999, flat fee of 1,000. As you go down, you can see we've got a proposal, not a proposal, but set fees, flat fee, 800, 1,000, 2,000, 3,000. When we go over again that benchmark of the $50,000 dispute, we're then starting into hourly rate fees. Now, that's not to say that if you're sitting down with your adjudicator, it's whatever you're agreeing to with your adjudicator, right? That's it. I learned this years ago. I remember in law school, BATNA, best alternative to a negotiated settlement or a negotiated agreement. Everyone knows that this chart is sitting out there, right? So they always have in the back of their mind, if I don't agree to this, ODAC's going to set it at this. So that is out there. For the most part, adjudicators are pretty much agreeing with their parties to something along the lines of this schedule of fees, because if they don't, they're getting this schedule of fees. And this is what's going to happen at the end of the day.
And Elise, I think that you make a really good point. And the thing is, you don't have to use this schedule of fees. You can sit down and negotiate fees with, the other party you're in dispute within the adjudicator. You can negotiate a flat fee. It all depends on the complexity of your case. And every case is going to be different. It's going to have nuances. And the adjudicator can set the process. The adjudicator may well say to you, okay, I've got enough information from the two parties. Thank you very much. Here's the process I'm going to use. And the adjudicator has the right to do that under the Act. So, but the adjudicator knows they've got 30 days. And there's all, so you can't have, 14 bankers boxes on both sides of the dispute to read through, because you're not getting through them in 40 days. So this is going to be 30 days. You're going to be very succinct. It's going to be efficient. That's the whole nature of adjudication. So the fees are not going to be outrageous. They're going to be proportionate to the dispute, and proportionately also will be the amount of information you get to submit to make your case, and you'll have to be right to the point. So it is efficient, and so far, I think, when we have our quarterly adjudicator meetings that Elise leads, and amongst the adjudicators, that part seems to be working out fairly reasonably well.
So just curious, is the timing of it has to be 30 days, or does the arbitrator or the adjudicator have the ability to expand that?
So there's a 14-day extension that you can formally request if you're either the respondent, the claimant, or the adjudicator, to add on to the 30 days. So you go to 44 days, but all parties have to agree to that 14-day extension.
Yeah, and I'll add one point to Matt's point. So if it's the adjudicator making the request for the extension, it's the 14 days. You're limited to the 14 days. But if it's a party to the adjudication making the request, the party can make the request for any amount of time, as long as everybody agrees to that.
Okay. Okay. That's what I was getting at. So as long as everyone's in agreement, then they can expand the timeline, right?
Right.
Yep.
But if it's the adjudicator making the request, the adjudicator can go no more than 14 days.
Okay. So I have a very obvious question that I was going to ask, and yet one of our members beat me to the punch, which is not shocking because it's Brian Arnold, our vice chair, who was incoming. And the question is quite succinct. Why does the hourly rate increase as the size of adjudication is increasing? Why not an hourly rate as an hourly rate? Just curious.
Well, Brian, that is the rate program that's been put down, and Elise has the background, and it's not that the adjudicators necessarily agree with it, because so you can sit down with an adjudicator and say, look, I've got a $5 million dispute, but I'm not paying $800 an hour or $1,000 an hour, and you can negotiate, and all the adjudicators are pretty much open for that. So that, you had to put something on the website, and Elise has the more detailed background, but a part of it is dictated by the Attorney General's office and ODAC's, assignment and their contract. But the adjudication fees are a suggestion. The parties are free to negotiate with the adjudicator the fee structure that works for their particular dispute.
Okay.
And I think, throwing in the numbers, because I know everybody loves those stats, 80% the parties are agreeing on the fee. Okay, 20% they're coming and knocking on ODAC's door and saying, you need to set the fee for me. So the numbers speak for themselves.
Yeah, right on.
Okay, so let's get into it. Let's roll through these slides, and then we're going to get into some more bantering back and forth between the three of us and all of you out there. Let's go through the slides, and let me show you the simplicity of commencing an adjudication on the system. A lot of these slides are taken as screenshots from our actual system. I mentioned earlier, your starting point is our website. You're going to log in. Here's our login page. You're going to create an account. The system will prompt you through creating your notice of adjudication. Click on new case. You're going to then start to put in some details. your claimant. If you're represented, we have sometimes you're represented by counsel, so maybe your lawyer will actually create the case on the system on your behalf. Sometimes it's you, but you will also be represented. We have room for, we have many adjudications where parties are not represented, and we have many cases where parties are represented. So there really is a mix of everything. You will indicate whether you're represented or not. You're going to indicate what industry the case is. Is it a residential matter? Is it commercial? Is it public buildings, transportation and infrastructure? We're going to ask you for the date of your construction contract. This is all part and parcel of creating your case. Then the next thing as we move along, we're going to ask you for what the dispute amount is. And obviously that has significance in terms of with the fees as well. And then there's going to be two areas that we're going to ask you to give us a brief description of your dispute. And Matt touched on this earlier. I think it's really important. The more details that you can put in there, the better. You're going to give the description there. And then below, you're going to it says nature of redress sought. I know it's not so clear. It's a little smaller, some of the screenshots, but nature of redress. What are you asking your adjudicator to do?
So Elise, when you come down for the dollar figure, I'm assuming that you have to back that with evidence and you're not just pulling that number out of the sky.
Well, no evidence yet. You just need to put the value of the dispute down. And then you're going to submit your documents. Once the adjudicator is decided, the claimant has 5 days to submit the documents. And in that documentation, you better be backing it up. Or
so this is what I'm getting at. There has to be some sort of evidence based. You can't just, you know, if it's a $5,000 claim, I can't say $1 million, right? You know what I mean? Like it has to be based on some sort of evidence.
Yeah, because you risk the adjudicator saying, hey, you're being frivolous and you're being abusive. And you could find that the adjudicator will find against you for all costs. So you have to be very careful. You need to be fair. You need to be succinct and to the point. Back it up. The adjudicator, remember, this is a short period of time. The adjudicator has 30 days, and you got to be succinct and give them the information to make the decision that you feel you need for the adjudicator to make the decision that will in your benefit.
Fantastic. Okay, Elise, keep going.
Okay, and Matt touched on this earlier, which I think is important, but just in creating your notice, what we want to know, what we're asking the claimant to do, and you'll see we ask the same of the respondent when they file their response if they choose to, we're asking you to, on your notice of adjudication, to suggest or propose a process. And on our website, we have 4 processes set out there and a custom process. And I'm going to show you on the next slide, I'll tell you what I mean by that. But again, it's all about proportionality, and Matt touched on this. The idea behind adjudication is we want to, the disputes and the fees and the time frame all to be sort of in proportion to one another. So if you're at a claim that's for $5,000, you don't want to be hit with a huge fee, and you don't want to be hit with this long drawn out process as if when you go to court with all these, as Matt said, these banker boxes coming in, you know, at whatever size. So what you're going to ask, the claimant's going to be asked to suggest a process. I'm going to, and that'll kick home and bring more relevance on the next slide on the notice of adjudication. You're also going to be asked to suggest an adjudicator from our list. And that goes back, and please hear Matt on what he said with picking an adjudicator, because those points are really well taken. So make your suggestions on your notice of adjudication. So when you're suggesting a process, and this is all on the website, so there's nothing to have to write down or record, we suggest, and I will say it again, we suggest on our website 4 design processes. They are not engraved in stone. There's also what's known as a custom process, sitting down with your adjudicator and making a process. And I'm going to let Matt speak about this after, but let me just give you a quick roll through so you know what I mean. So if you're process 1 here, the method of adjudication will only be in writing. We're going to ask for your construction contract if one exists. The parties, in terms of their submissions, what they want to tell the adjudicator about their case is going to be limited to 2 pages per party. There's not going to be any additional documents. You're going to get a determination from your adjudicator, 1 to 2 pages, and you're going to have a flat fee of $800. That's $400 per party. Okay. As we get to the more complicated, not maybe or not maybe, higher price disputes, it really depends, as Matt said. Let's just jump to process 4 so you can kind of see the difference. Your method of adjudication for process 4, it's writing, and maybe there is an oral presentation. Maybe the adjudicator is going to say, you know what, I want to hear from everyone. Claimant, you have half an hour. Respondent, you have half an hour, no more. And I've seen adjudicators cut people off for time and cut people off for number of pages. So beware, because when they say and they set your process, hopefully they're sticking to your process, and you will be thankful for that at the end of the day. So process 4 might be writing an oral hearing. We've got your contract included. And now the adjudicator is saying, you know what, I will take 10 pages from each party, opposed to 2 pages in terms of your submissions, what you want to tell your adjudicator. Process 1 had no additional documents. Well, process 4, if you're using the guidelines or following that, the adjudicator is saying, okay, I'm going to allow an extra 25 pages to submit to me, whatever that might be. And my flat fee is going to be $3,000. And again, I don't want you to think that these fees are engraved in stone with the process and tied together. It is a mutual effort, speaking with your adjudicator. And Matt, I don't know if you have anything to add on that.
I think that's quite right. And I think please don't think about this as a court proceeding. It is not. Please don't think about this as arbitration if you've been through that, because it's not. And please don't think it's mediation, because it's not a mediated settlement. Okay. Adjudication is a new process that's been introduced in Ontario, and it is designed to be fast. And the suggested processes that Elise has just described are giving you an inkling as to how the information will be presented. You're not going to have a massive affidavit of documents because there's no time to read it. So you got to boil it down to the essential documents, and you got to articulate it succinctly. And so if you're not satisfied with one of the suggested ODAC processes, and you don't need to use them even if you are satisfied with them, but if you think your particular situation's a little bit different, you can sit down with your adjudicator and walk through that with them. And as an adjudicator, that's one of the things that's on the agenda with the first call I'll have with both parties. Beyond finding jurisdiction, I want to understand thoroughly what the dispute is to be able to say, okay, you know what, this is how we should proceed. This is what, as an adjudicator, I think I would need. And, these 4 processes wouldn't apply in this set of circumstances, and maybe it's something a little bit different. So, and that conclude a site visit. It doesn't always. There has been very few site visits to date, as Elise will confirm. But it could, it could well involve a site visit. It may or may not involve an oral hearing. The vast majority of adjudications do not involve an oral hearing. They're based on fact and presented in documents. So, anyways, just a bit of background for you to think about as you go about an adjudication.
Right. So, sorry, just so I want to. So again, when you're doing your form, just going back. So then you're going to put down, again, a proposal, 1, 2, 3, 4, or custom. You're going to put in your adjudicator as well. So now you've got your notice of adjudication is completed. The system's going to acknowledge that a notice of adjudication has been filed. It will then send the respondent an email. The email will be along the lines of an adjudication has been commenced against you. Please click here to view the notice of adjudication. If you haven't set up an account, click here, set up account, and then you can view your notice of adjudication. You will then be prompted to, and you will see the Construction Act say that a respondent may file a response. So it is up to the respondent whether they choose to file a response or not file a response. And Matt can comment on that because I won't.
Okay, but doesn't it make any sense if I'm the respondent that I should take a position? If I don't, the adjudicator is going to basically find, or rule against me without any documentation.
Well, therein lies the issue, because the adjudicator under the Act has the ability to rule if one party does not respond, the adjudicator still has an obligation under the Act to issue a determination. So it's very clear that you do want to respond if you want to protect your rights and get your arguments up.
Okay, so if I'm a respondent and I get this notice, Elise, that I'm now going to be subject to this process, can I object to the process?
No, part of Matt Ainley, construction consultant, provides services around strategy for these kinds of things. So we won't comment on that today because we're not here to talk about strategy.
Okay.
But and there is obviously strategy. There's strategy if you're going to lien, there's strategy if you're going to go to arbitration, there's strategy if you're going to go to mediation. That's all natural. I mean, things evolved, and it's no different with adjudication. But today it's about the rules, and you do want to respond. You have to respond, I think, Giovanni.
Okay, so Elise, please continue. I know that you've got a couple of slides left, and we're reaching the top of the hour. This conversation has gone very quickly.
So I'm just going to quickly go through these. The respondent's is going to file similar things that the claimant did. They're now going to put in their proposal for a process, and then the banter back and forth between the two parties on the adjudicator. So the respondent has three options. One, they can agree to the proposal that the claimant made in their notice of adjudication for an adjudicator. Two, they can say, I want to suggest another one. Or three, they can ask ODAC to appoint. So there's a bit of a tennis match back and forth. It can go back and forth a few times in terms of proposals until one party says, ODAC, please appoint. These are just screenshots to show how the system looks in terms of responding, suggesting an adjudicator, and then the claimant responds to the respondent's proposal. We eventually have an adjudicator. The parties have agreed. If just a few questions that I get on a regular basis. Again, what happens if they don't agree? ODAC appoints. But point number two, is ODAC going to consider the adjudicators that have been put forward by the claimant or respondent when we appoint? And the answer is no. We are going to be appointing an adjudicator, someone other than the ones proposed by the parties. And Matt touched on this as well in terms of the contract. And I think Giovanni, you asked this as well. What if my contract or subcontract purports to name a person to act as an adjudicator? In the event of an adjudication, may I use that adjudicator? And the answer is no.
The Act forbids it.
Okay,
so Elise, in the interest of time and questions, here's what I would like to suggest.
Sure.
There's a lot of good slides here, and I will tell you that I've used the system a couple times. So if anybody that knows me on this call will know that I'm not exactly the most technically savvy person, but this
we figured out when you lost your internet.
Yeah, thank you very much. I proved that, right? But this system works very well. It is user friendly, and all the documentation is captured in the system. It doesn't take you very long to work it out. And I think I completely endorse it. I mean, I think it's a terrific system, and then the documents are preserved. So if you end up having to go to trial later, they're all there. They keep the records for the mandatory 7 or 10 years, whatever the statutory period of time is on that. And so it is a great system, and I think you're gonna have no problem. And Elise sort of showed you the tip of the iceberg, but every subsystem that you get into is easy. Uploading documents is easy. Everything is user intuitive, so it's not a big deal.
So I have a burning question.
Yeah.
So I know you mentioned that it's not a court proceeding, it's not an adjudication. Just out of curiosity, but sorry, it's not an arbitration. Is an adjudication can it be subject to a judicial review?
Yes, it can be. The terms of judicial review are very narrow. The parties have 30 days after an adjudicator decision to appeal. And it can, and it's very narrow. So, I mean, there's a bunch of reasons, but the top ones are, was the adjudicator certified under ODAC? Did you use an adjudicator that wasn't? So that is appealable. You can appeal on the basis that the ruling wasn't on what was discussed or what was agreed to adjudicate. But you can't appeal on the facts. You can't appeal on any of that. If one of the parties was incapacitated or the contract ceased to exist, I mean, it had been completed, for example. So it's very broad, the issues that you can appeal on. Again, it's one of the things that gives an adjudicator's determination a lot of strength.
Interesting. I just thought of the comment that you made about, a lawyer admitting that they didn't know something, which is never going to happen. But anyway, especially if it was like a geotechnical matter, and can I sit there and appeal or go to a judicial review if I don't believe that the ruling was sound? So you've just answered that question. I think I've heard you. Yes, you can.
Yeah. So one of the things, so just part of how to use the act, you don't give up your lien rights. Okay. So you've never given up. So you might adjudicate, lose, and still feel that the determination that you received is factually incorrect. And in fact, you think if you go for a full judicial review, which includes affidavit documents and, whether you're in the court or through arbitration, that is still available to you. You can still go the old standard way, lien the project, get into the lien courts and get your case heard that way as well. So that still exists. This is an interim decision. And one of the interesting pieces that you should know, I mean, striking the balance report that was done for Ontario back when this act was, conceived for prompt payment and adjudication, we looked to England, and the English statistics are astounding. Like there are 1,500 adjudications a year on average for at least the last 15 years or thereabouts. I mean, it fluctuates a bit, but not much. And 97%, 98% of all the determinations stand. Of the 3% or so that go to the courts because parties are unhappy, 98% of those decisions are upheld by the judges who say, yes, we agree with the adjudicator's decision. So very few are overturned. So I think that's the part that we're still in the early days of. We haven't got a lot of determinations. I think Elise is just about to give us some stats here. So I think this may be a good time for that, Elise.
Right. So the adjudication provisions and people's right to adjudicate started October 1, 2019. So since that date, we've had 72 adjudications that have been initiated with ODAC. We currently have 30 determinations. At the beginning, there were a number of terminations. So people would commence their adjudications and they would terminate midway, partially because the parties went off and they just settled. I think it brings a lot of the parties to the table to actually settle. So we had terminations based on settlement. We had some terminations based on jurisdiction. They realized that they couldn't adjudicate because their matter didn't fall within the provisions of the Construction Act with the recent changes of when you can actually adjudicate. I think the trend now is we also have this thing called COVID out there. So I think the numbers are affected with that. And I think it's just a general awareness. This is something new, and this is people know about it, but don't really know about it. And they're sort of testing the water. And I think there's that educational piece, there's the awareness piece, there's moving away farther from October 1, 2019 in terms of jurisdictional issues, in terms of commencing your adjudication. So we have 30 determinations. We have a number of adjudications on the go now that will be coming out with determinations over the next several weeks. In terms of sectors, we have, I'd say about 50% right now are at the are in residential, but we have adjudications in all the various industries: commercial, transportation, infrastructure, public buildings, and industrial. I gave you some stats in terms of where the parties are agreeing on the adjudicator and where they're not, and setting the fee. I have to say the trend is a couple trends. One is we are not seeing the number of terminations that we did at the beginning. We are definitely seeing parties leaving the adjudications feeling really satisfied and happy with the in terms of effectiveness, in terms of cost and timing. people are living with the decisions. That's definitely the trend. And there was one other point I was just going to mention as well that just escaped me for a minute. But and if Matt has anything to add on that in terms of his actual experience with the adjudicate. Oh, sorry, came back
Go
to
ahead.
me.
Go ahead.
Site visit as well. So everything is really online. I mean, all the documents are uploaded. Everything is online. There are no, if there's an oral hearing, it's all online. Documents are sitting online. There's a message tab. Everyone's communicating online. Of all the cases, the 72, we had one or two, I think 2 site visits. And I don't really think that's just a COVID issue. I really, if I had my crystal ball, I would say the trend is that there are going to be less site visits with this process, but obviously that remains to be seen. Matt?
Yeah, I was going to say one of the encouraging stats is that a number of the adjudications filed ended up just being terminated. And that's because one party wasn't coming to the table. And that's, I think a cultural thing. So if you're in the supply chain and you're the bottleneck on a particular issue, you're not paying on time, or you're not processing the changes on time, or you're arguing over price excessively, you can get called out fairly quickly by an adjudication being claimed against you if you're that party, obsessing over the right price. And then the adjudicator can then obviously make that determination. But the fact that it's been a claim has been filed against you is going to now bring you to a time frame. You can no longer argue forever. You're now on the clock, and that has forced, I think, a lot of parties to begin proper negotiations in good faith, and that's why we're seeing some of the terminations of these adjudications. So it's a good thing, but we're still in the early days. I think it's going to probably be another year before we get over the major hurdle of transition from the old act to the new act, where it's, we've got enough projects started clearly in the new act to get progressively far enough along where there are disputes, as there naturally are sometimes in construction projects. And then, adjudication might start getting used a lot more. And as Elise has said, the uptake lately has been slightly increasing. So we're beginning to see some of that as well.
So I'm very cognizant of time. We're 9 minutes over the 11 o'clock cutoff, but I've got 2 questions that I'm dying to ask. The first one came again from Brian Arnold. Excellent question. And I was going to ask this question of you, which is, how do you avoid the so-called ambush effect when the parties are filing on like December 24th, especially given the strict timelines where they're calendar days and not business days?
Yeah, it's a great question, and I don't know that you can. If one party wants to be bad behaving, then it's a difficult thing to do. So there's a lot of lobbying going on to change the act to do that, and particularly in the other provinces. England saw that initially. It seemed to die down after about 4 or 5 years. This is what the adjudicators in England are telling us. We've had several conversations with them. So it did eventually die down because a lot of the adjudicators would look at that and say, okay, I'll take that on the 25th. Sure, I'll take my 4 days. So that gets me to the 28th to say yes. And I'll give 5 days, then 5 days for the the claimant to submit their documentation. And what they do is they actually give the respondent a lot more time to get their response in, because obviously you're in the middle of holidays. But then the adjudicator is now prejudiced, of course, because right, there's no question, like
due to the ambush effect.
You've been ambushing and you're not willing to to play fair. So now you've got an adjudicator who's not necessarily is supposed to be really fair, but let's face it, you've ruined their Christmas. And human nature is human nature. So you need to think about that. And that's, I think, what sort of leveled the playing field in England, is that people started saying, you know what, this may not be the right thing to do. So I think there's always bad actors out there, and for the audience, we've all sadly probably had that experience with the some of the folks we deal with on contracts, but hopefully it's to a minimum.
So the last question I have, and in keeping with the bad actors kind of scenario, what if, you get a decision by an adjudicator and the responding party just refuses to pay? What recourse do you have?
So the recourse is, as we described, and Elise mentioned it as well, is that if they don't pay within 10 calendar days, the winning party takes the determination of the adjudicator, files it to the court. The mere act of filing it in the court, it becomes a court order to pay. Then you have the right, as the winning party, to walk off the job without defaulting your contract. You get demobilization costs, you get interest at the 10-day period onwards, and you get remobilization costs once everything is paid to remobilize back on site. So you have quite a bit of power, and the courts will not take kindly, because now that you have a court order, you go to your lawyer and you go enforce a court order. So that has a whole other set of implications that are obviously outside the Construction Act, because there's other acts that prevail in that case.
So we're at 12 minutes after 11. We're over, and I want to thank the participants that have hung on. Obviously, we've recorded this just so that we can broadcast this out afterward, just in case, because we've got some excellent questions that have come in. And clearly, this is an evolving document in the sense of, we're only in early days when it comes down to the number of arbitrations that we've been able, or the adjudications. I keep getting those mixed up. My apologies. The adjudications that we've done. We may need to revisit this in a year's time and see where we're at. And then, Elise, as the authority, will be able to respond to us and say, we've now gone through a litany of this, and this is where we're at averaging, and hopefully, we'll reach some sort of comfortable balance. I'd like to think that we don't need 4 years' time like England did in the UK, and that we'll be able to expedite that in a rather interesting fashion. But I do want to thank you on behalf of the OGCA and all of the members that participated today. It's been riveting. It's been a lot of fun, and the amount of content that you have and the knowledge is amazing. So if anyone has any questions as a follow-up, you can either submit them directly to the OGCA, or please, Elise and Matt are here. Their contact info is in the deck, and we'll be able to provide the deck out to everyone. And with that being said, we want to humbly thank you very much for your time, your energy, and the imbuing us with such knowledge. So Elise, Matt, thank you very much. It's been an absolute pleasure.
You're quite welcome.
Thank you. Thanks so much for having us. I really appreciate it. It was a pleasure. And yes, I am here to answer questions. There's the contact information once again for both Matt and myself. So please reach out with any questions.
Yeah, we got a question after the hour. I'm going to send it to you because we've run out of runway at this point in time. So thank you all very much, everyone.
Okay, take care.
Right.
Bye-bye.
Thanks, Giovanni. Thanks, Elise.
Thank you.